purpose in examining whether there exists an agreement that is not in written form regarding the maritime boundary between two states. In this regard, the Court recalls that acquiescence is equivalent to tacit recognition manifested by unilateral conduct which the other party may interpret as consent. If the circumstances are such that the conduct of the other state calls for a response within a reasonable period, the absence of a reaction may amount to acquiescence. In determining whether a state's conduct calls for a response from another state, it is important to consider whether the state has consistently maintained that conduct. In evaluating the absence of a reaction, duration may be a significant factor. The Court has set a high threshold for proof that a maritime boundary has been established by acquiescence or tacit agreement. It has emphasized that since the establishment of a permanent maritime boundary is a matter of grave importance, evidence of a tacit legal agreement must be compelling. Acquiescence presupposes clear and consistent acceptance of another state's position. To date, the Court has recognized the existence of a tacit agreement limiting a maritime boundary in only one case, in which the parties had acknowledged in a binding international agreement that a maritime boundary already existed. In the present case, the Court will use the criteria it has identified in earlier cases and examine whether there is compelling evidence that Kenya's claim to a maritime boundary at the parallel of latitude was maintained consistently and consequently called for a response from Somalia. It will then consider whether there is compelling evidence that Somalia clearly and consistently accepted the boundary claimed by Kenya. In this respect, the parties present arguments regarding the proclamations by the President of the Republic of Kenya dated 28 February 1979 and 9 June 2005, to which I shall refer as the 1979 proclamation and the 2005 proclamation, as well as Kenya's 2009 submissions to the CLCS and their respective domestic laws. They also refer to other conduct of the parties in the period between 1979 and 2014. The Court examines these arguments in turn. The 1979 proclamation was concerned with Kenya's exclusive economic zone. It stated that, I quote, "The exclusive economic zone of Kenya shall, in respect of its northern territorial waters boundary with Somalia, be on latitude 1 degree 38 minutes south." The Court notes, however, that Section 2, subsection 4 of Kenya's Territorial Waters Act of 1972, which remained in force when the 1979 proclamation was issued, stated that, I quote, "On the coastline adjacent to neighboring states, the breadth of the territorial sea shall extend to a median line," end of quote. The Court thus observes that Kenya was not consistently claiming a maritime boundary with Somalia at the parallel of latitude in all maritime areas. On 25 August 1989, shortly after ratifying UNCLOS, Kenya adopted the Maritime Zones Act, which is still in force. In respect of the delimitation of the territorial sea, Section 3, subsection 4 of the 1979 Maritime Zones Act provides, I quote, "On the coastline adjacent to neighboring states, the breadth of the territorial waters shall extend to a line every point of which is equidistant from the nearest points on the baselines from which the breadth of the territorial waters of each of the respective states is measured," end of quote. As regards the delimitation of the exclusive economic zone, Section 4, subsection 4 of the Act provides that, I quote, "The northern boundary of the exclusive economic zone with Somalia shall be delimited by notice in the Gazette by the Minister pursuant to an agreement between Kenya and Somalia on the basis of international law," end quote. The Court considers that Kenya's position is at odds with the text of the 1979 Maritime Zones Act, which refers neither to the 1979 proclamation nor to a boundary at the latitude for either the territorial sea or the exclusive economic zone. In respect of the exclusive economic zone, the text of Section 4, subsection 4 of the 1989 Maritime Zones Act provides that the northern boundary of the exclusive economic zone with Somalia shall be delimited pursuant to an agreement between Kenya and Somalia. These words stand in contrast to the text of Section 4, subsection 3, which provides that the southern boundary with Tanzania shall be on an easterly latitude, employing similar terms to those found in the 1979 proclamation. Section 4, subsection 4, thus implies that, unlike the situation of the boundary between Kenya and Tanzania, Kenya considered in 1989 that there was no agreement with Somalia on their maritime boundary. The Act refers instead to an agreement to be concluded and published in the future. It was therefore reasonable for Somalia to understand Kenya's position to be that an agreement was to be negotiated and concluded at a later date. Kenya's 2005 proclamation replaced the 1979 proclamation while generally reaffirming its terms. With regard to the exclusive economic zone, the 2005 proclamation modified the parallel of latitude claimed as the boundary with Somalia. The proclamation included two schedules, one of which implying that for Kenya, the boundary of its territorial sea with Somalia also followed the same parallel of latitude. Kenya has also drawn the court's attention to two notes verbal from the Ministry of Foreign Affairs of Kenya to the Ministry of Foreign Affairs of the Transitional Federal Government of Somalia, dated 26 September 2007 and 4 July 2008. In the note verbal of 26 September 2007, which concerned the process of delineation of the outer limits of its continental shelf, Kenya claimed that the maritime boundaries between the two countries have been drawn using the parallel of latitude in accordance with Article 7483 of the UNCLOS, and requested Somalia to confirm, I quote, that the transitional federal government agrees with the way the maritime boundaries between the two countries are drawn as deposited with the United Nations by the government of the Republic of Kenya, end quote. The aide memoire attached to the note verbal stated that the boundaries between our two countries have not been defined. In the note verbal of 4 July 2008, Kenya asked the government of Somalia, I quote, to state its position to the government of the Republic of Kenya that the transitional federal government of Somalia agrees with the maritime boundaries between the two countries as drawn and deposited with the United Nations by the government of the Republic of Kenya, end quote. The court observes that the notes verbal did not characterize the maritime boundary claimed by Kenya as an agreed boundary, but rather invited Somalia to confirm its agreement. It has not been shown that Somalia provided such confirmation. The court then examines Kenya's 2009 submission to the CLCS, observing that the list of coordinates and the maps included by Kenya in its submission show a single maritime boundary with Somalia at a parallel of latitude extending beyond 200 nautical miles to the claimed outer limit of its continental shelf. The court notes that Kenya's 2009 submission to the CLCS was made for the purpose of delineating the outer limits of its continental shelf, which is a process distinct from the delimitation of continental shelf. In this regard, Kenya's submission indicates that, I quote, Kenya has overlapping maritime claims with the adjacent coastal states of Somalia to the north and with the United Republic of Tanzania to the south, end of quote, and mentions that Kenya and Somalia had signed in 2009 a Memorandum of Understanding, which I shall refer to as the MOU, agreeing that they would not object to each other's submissions to the CLCS. As previously noted by the court in the 2017 judgment, the terms of the MOU suggest that the two states recognize that they have a maritime dispute that is unresolved, and identify the area under dispute as that in which the claims of the two parties to the continental shelf overlap, without differentiating between the shelf within and beyond 200 nautical miles. They also suggest that the parties intended to acknowledge the usual course that the limitation would take, namely engaging in negotiations with a view to reaching agreement. In this connection, the MOU provides that, I quote, the delimitation of maritime boundaries in the areas under dispute shall be agreed between the two coastal states on the basis of international law, end of quote. The court observes that Kenya's 2009 submission to the CLCS also alludes to the lack of agreement between the parties on the maritime boundary in the exclusive economic zone. In respect of the boundary with Tanzania, the submission explains that an agreement is in place between Kenya and Tanzania concerning the delimitation of maritime boundaries. However, in respect of the boundary with Somalia, the submission states that the exclusive economic zone boundary, I quote, shall be delimited by notice in the Gazette by the minister pursuant to an agreement between Kenya and Somalia on the basis of international law. End of quote. Thus employing the same terms as Section 4, Subsection 4 of the 1989 Maritime Zones Act. The submission also notes the existence of an unsettled boundary line between Kenya and Somalia. From these terms, it was reasonable for Somalia to maintain its understanding that an agreement had yet to be negotiated and concluded. On 26 and 27 March 2014, at the request of the Kenyan government, the parties met in Nairobi to engage in negotiations on maritime delimitation. The mere fact that these negotiations took place suggests that the parties recognized the need to delimit the maritime boundary between them. This is confirmed by the parties' joint report on the negotiations, which states that they considered several options and methods, including bisector, perpendicular, median, and parallel of latitude, but that they could not reach a consensus on the potential maritime boundary line acceptable to both countries to be adopted. Nowhere does the report imply that there already was an agreed maritime boundary between the parties. Finally, the court observes that Kenya's recognition that no agreement on the maritime boundary with Somalia had been reached was also reflected in its two notes verbal to the Secretary General from the Permanent Mission of Kenya to the United Nations, dated 24 October 2014 and 4 May 2015, and in its statements made to the court during the preliminary objection phase of this case. In light of the foregoing, the court concludes that Kenya has not consistently maintained its claim that the parallel of latitude constitutes a single maritime boundary with Somalia. Kenya's claim was contradicted by its Territorial Waters Act of 1972, which remained in force in 1979, its 1989 Maritime Zones Act, and its 2009 submission to the CLCS. Under these circumstances, it was reasonable for Somalia to understand that its maritime boundary with Kenya in the territorial sea, in the exclusive economic zone, and on the continental shelf would be established by agreement to be negotiated and concluded in the future. The court thus concludes that there is no compelling evidence that Kenya's claim and related conduct were consistently maintained and consequently called for a response from Somalia. The court then recalls that Kenya's claim of acquiescence is based on Somalia's alleged acceptance of a maritime boundary at the parallel of latitude, in particular through its prolonged absence of protest. The court addresses this argument of Kenya, bearing in mind the conclusion just mentioned. It notes in particular that in the years immediately following Kenya's 1979 proclamation, the parties engaged in discussions on a variety of issues relating to their bilateral relations, such as trade and exploitation of marine resources. However, there is no indication that Somalia accepted Kenya's claim to a boundary along a parallel of latitude during that period. In this regard, Kenya has submitted minutes of a meeting held between the vice presidents of the two states on 6 May 1980. But these minutes make no mention of any discussion of the parties' maritime boundaries or the 1979 proclamation. The same is true of other evidence submitted by Kenya in relation to meetings held by the parties in 1981. Until 1989, Somalia did not claim an exclusive economic zone or define its continental shelf. Shortly before ratifying UNCLOS, Somalia adopted the Maritime Law of 1988, approved by Law No. 5 on 26 January 1989. The Maritime Law does not refer to the delimitation of either the exclusive economic zone or the continental shelf. Article 4 defines Somalia's territorial sea as extending to 12 nautical miles and addresses the issue of its delimitation with Kenya, providing in the relevant part of paragraph 6, I quote, "If there is no multilateral treaty, the Somali Democratic Republic shall consider that the border between the Somali Democratic Republic and the Republic of Djibouti and the Republic of Kenya is a straight line towards the sea from the land as indicated on the enclosed charts." End of quote. Somalia has not produced the charts mentioned in the provision, explaining that they may have been lost or destroyed during the Civil War. It maintains that the phrase straight line towards the sea was intended to be equivalent to an equidistance line. Kenya contends that although the meaning of the phrase is unclear, taking Somalia's contemporary practice into account, it should be interpreted as a reference to the parallel of latitude. The Court notes that Article 4, Paragraph 6 of the Maritime Law also refers to the delimitation of maritime areas in relation to the Republic of Yemen, employing the phrase a median line. The phrase a straight line towards the sea is not clear, and without the charts mentioned, its meaning cannot be determined. Somalia did not react immediately to the 2005 proclamation. However, its view was made clear on several occasions in 2009. As noted earlier, the MOU concluded that year between the parties referred to an unsettled maritime dispute. Somalia's 2009 submission of preliminary information to the CLCS reproduces the text of the MOU and indicates that unresolved questions remain in relation to the bilateral delimitation of the continental shelf with neighboring states. In addition, in a letter dated 19 August 2009 and addressed to the Secretary General of the United Nations, the Prime Minister of Somalia maintained that the delimitation of the continental shelf has not yet been settled, further stating that, I quote, "It would appear that Kenya claims an area extending up to the latitude of the point where the land border reaches the coast, while instead, in accordance with the international law of the sea, an equidistance line normally constitutes the point of departure for the delimitation of continental shelf between the two states with adjacent coasts. Somalia bases itself on the latter view." End of quote. Further, as noted by the Court in the 2017 judgment, in 2014, Somalia objected to the consideration by the CLCS of Kenya's submission on the ground that there existed a maritime boundary dispute between itself and Kenya. Somalia withdrew its objection in 2015, noting that the dispute had been submitted to the Court. Finally, the Court cannot ignore the context of the civil war that afflicted Somalia, depriving it of a fully operational government and administration between 1991 and 2005. These circumstances were public and notorious, and they were also recognized by Kenya in the previous phase of the proceedings. This context needs to be taken into account in evaluating the extent to which Somalia was in a position to react to Kenya's claim during this period. For the foregoing reasons, the Court considers that the conduct of Somalia between 1979 and 2014 in relation to its maritime boundary with Kenya, as just examined, in particular its alleged absence of protest against Kenya's claim, does not establish Somalia's clear and consistent acceptance of a maritime boundary at the parallel of latitude. The Court then examines Kenya's argument that other conduct of the parties between 1979 and 2014, in particular their practice concerning naval patrols, fisheries, marine scientific research, and oil concessions, confirm Somalia's acceptance of a maritime boundary at the parallel of latitude. The Court recalls that in the context of a maritime delimitation dispute, as for territorial disputes, the date on which the dispute crystallized is of significance. Acts occurring after such date are in principle irrelevant to the determination of a maritime boundary and cannot be taken into account, having been carried out by a state which, already having claims to assert in a legal dispute, could have taken those actions strictly with the aim of buttressing those claims. The Court recalls that the MOU concluded by the parties in 2009 and Kenya's 2009 submission to the CLCS indicate that a maritime dispute existed between them as of 2009. Somalia has not provided the Court with sufficient evidence to conclude that the dispute emerged before 2009. Accordingly, the Court considers that the parties' activities after 2009 cannot be taken into account for the purpose of determining the maritime boundary. The Court begins by considering the evidence of naval patrols. Maps depicting and logs recording Kenya's naval patrols and interceptions in the territorial sea show that some law enforcement activities were conducted by Kenya north of the equidistance line claimed by Somalia. Occasionally, however, there were also conducted north of the parallel of latitude that it claims as the maritime boundary. Kenya's naval patrols and interceptions were thus not necessarily consistent with its maritime boundary claim. Moreover, one of the maps submitted by Kenya is marked secret, and the remaining evidence does not establish that Somalia had knowledge of these activities. For the reasons given in the judgment, the Court considers that the evidence on fisheries and marine scientific research activities also does not support Kenya's claim. As regards oil concessions, the Court notes that the parties have established offshore oil concession blocks employing different lines since the 1970s. However, the parties have referred only to limited practice that took place before 2009. For the most part, the parties have referred to practice after 2009, which, for the reasons previously explained, is irrelevant to the determination of the maritime boundary. The court notes Kenya's argument that the conduct of the parties, including with respect to oil concessions, reflects the existence of a de facto maritime boundary. Even assuming that the limited evidence of practice before 2009 could be taken to suggest that a de facto line along the parallel of latitude may have been used by the parties for the location of oil concession blocks, at least for some time, the court observes that this may have been simply the manifestation of caution exercised by the parties in granting their concessions. The court also recalls that a de facto line might in certain circumstances correspond to the existence of an agreed legal boundary, or might be more in the nature of a provisional line or of a line for a specific limited purpose, such as sharing a scarce resource. The court considers that proof of the existence of a maritime boundary requires more than the demonstration of long-standing oil practice or adjoining oil concessions. For these reasons, the court considers that other conduct of the parties between 1979 and 2014 does not confirm that Somalia has clearly and consistently accepted a maritime boundary at the parallel of latitude. In conclusion, the court finds that there is no compelling evidence that Somalia has acquiesced to the maritime boundary claimed by Kenya, and that consequently, there is no agreed maritime boundary between the parties at the parallel of latitude. Kenya's claim in this respect must therefore be rejected. In view of the conclusion just stated, the court turns to the delimitation of the maritime areas appertaining to Somalia and Kenya. In its application, Somalia requested the court to determine on the basis of international law the complete course of the single maritime boundary dividing all the maritime areas appertaining to Somalia and to Kenya in the Indian Ocean, including the continental shelf beyond 200 nautical miles. Both Somalia and Kenya are parties to UNCLOS. The provisions of the convention must therefore be applied by the court in determining the course of the maritime boundary between the two states. The court begins by identifying the starting point of the maritime boundary. Although the parties initially preferred divergent views on the appropriate approach to defining the starting point to the maritime boundary, those views evolved in the course of the proceedings and are now, by and large, concordant. Taking into account the views of the parties, the court considers that the starting point of the maritime boundary is to be determined by connecting the final permanent beacon of the parties' land boundary, known as primary beacon number 29 or PB29, to a point on the low water line by a straight line that runs in a southeasterly direction and is perpendicular to the general trend of the coastline at Dar es Salaam, in accordance with the terms of the 1927-1933 treaty arrangement. The starting point is illustrated on sketch map number 3 in the judgment. The court next addresses the delimitation of the territorial sea. It notes that Somalia submits that the delimitation of the territorial sea is to be effected pursuant to Article 15 of the Convention, whereas Kenya argues that the maritime boundary, including the part in the territorial sea, already exists and that it follows the parallel of latitude. The court has already concluded that no such boundary was agreed by the parties. The court also notes that Kenya, in its counter-memorial, referred to the 1927-1933 treaty arrangement and stated that it, I quote, provided for the establishment of a boundary in the territorial sea, end of quote. The court notes that neither party asks it to confirm the existence of any segment of the maritime boundary or to delimit the boundary in the territorial sea on the basis of the 1927-1933 treaty arrangement. It recalls that in their legislation concerning the territorial sea, neither party has referred to the terms of the 1927-1933 treaty arrangement to indicate the extent of the territorial sea in relation to its adjacent neighbor. Kenya's legislation has referred to a median or covered all maritime zones, including the territorial sea. The delegations discussed several options and methods for determining the maritime boundary, although they could not reach agreement. In a presentation examining an equity-based maritime boundary scenario, which is attached to the joint report on that meeting, Kenya referred to Articles 15, 74, and 83 of the Convention as relevant to the maritime delimitation. It emphasized that Article 15 provides for a delimitation through a median line for the territorial sea, unless there is agreement to the contrary based on a claim by historic title or special circumstances. The Court therefore considers it unnecessary to decide whether the 1927-1933 treaty arrangement had as an objective the delimitation of the boundary of the territorial sea. The Court then recalls that the delimitation methodology is based on the geography of the coast of the two states concerned, and that a median or equidistance line is constructed using base points appropriate to that geography. Although in the identification of base points the Court will have regard to the proposals of the parties, it need not select a particular base point, even if the parties are in agreement thereon, if it does not consider that base point to be appropriate. The Court may select a base point that neither party has proposed. The Court further recalls that it has sometimes been led to eliminate the disproportionate effect of small islands by not selecting a base point on such small maritime features. As the Court has stated in the past, there may be situations in which the equitableness of an equidistance line depends on whether precaution is taken of eliminating the disproportionate effect of certain islets, rocks, or minor coastal projections. In the circumstances of the present case, the Court considers it appropriate to place base points for the construction of the median line solely on solid land on the mainland coast of the parties. It does not consider it appropriate to place base points on the tiny arid Dioa-Damaskia islets, which would have a disproportionate impact on the course of the median line in comparison to the size of these features. For similar reasons, the Court does not consider it appropriate to select a base point on a low tide elevation off the southern tip of Ras Kamboni, which is a minor protuberance in Somalia's otherwise relatively straight coastline in the vicinity of the land boundary terminus, which constitutes the starting point of the maritime delimitation. The Court then provides the geographical coordinates of the appropriate base points selected on the parties' coasts used to construct the median line. The resulting line starts from the land boundary terminus and continues to the point A, at the distance of 12 nautical miles from the coast. That median line is depicted on sketch map number 5, now shown on the screen. The Court observes that the course of that median line corresponds closely to the course of a line at right angles to the general trend of the coastline, assuming that the 1927-1933 treaty arrangement, in using this phrase, had as an objective to draw a line that continues into the territorial sea, a question that the Court need not decide. The Court then proceeds to the delimitation of the exclusive economic zone and the continental shelf within 200 nautical miles from the coast of the parties. The relevant provisions of the Convention for this exercise are contained in Article 74 of UNCLOS for the delimitation of the exclusive economic zone and Article 83 for the delimitation of the continental shelf. These provisions are of a very general nature and do not provide much by way of guidance for those involved in maritime delimitation exercise. The goal of that exercise is the achievement of an equitable solution. If two states have freely agreed on a maritime boundary, they are deemed to have achieved such an equitable solution. However, if they fail to reach agreement on their maritime boundary and the matter is submitted to the Court, it is the task of the Court to find an equitable solution in the maritime delimitation it has been requested to effect. Since the adoption of the Convention, the Court has gradually developed a maritime delimitation methodology to assist it in carrying out its task. In determining the maritime delimitation line, the Court proceeds in three stages, which is described in the case concerning maritime delimitation in the Black Sea, Romania versus Ukraine. In the first stage, the Court will establish the provisional equidistance line from the most appropriate base points on the coast of the parties. The Court will, in the second stage, consider whether there are factors calling for the adjustment or shift stage. The Court will submit the envisaged delimitation line, either the equidistance line or the adjusted line, to the disproportionality test. The purpose of this test is to assure the Court that there is no marked disproportion between the ratio of the lengths of the relevant coasts of the parties and the ratio of their respective shares of the parties in the relevant area to be delimited by the envisaged line, and thus to confirm that the delimitation achieves an equitable solution as required by the Convention. The The Court observes that the three-stage methodology is not prescribed by the Convention and therefore is not mandatory. It has been developed by the Court in its jurisprudence on maritime delimitation as part of its effort to arrive at an equitable solution as required by Articles 74 and 83 of the Convention. The methodology is based on objective geographical criteria, while at the same time taking into account any relevant circumstances bearing on the equitableness of the maritime boundary. It has brought predictability to the process of maritime delimitation and has been applied by the Court in a number of past cases. The three-stage methodology for maritime delimitation has also been used by international tribunals. The Court will not use the three-stage methodology if there are factors which make the application of the equidistance method inappropriate. For instance, if the construction of an equidistance line from the coast is not feasible. This, however, is not the case in the present circumstances, where such a line can be constructed. Moreover, the Court does not consider the use of a parallel of latitude as the appropriate methodology to achieve an equitable solution as suggested by Kenya. A boundary along the parallel of latitude would produce a severe cutoff effect on the maritime projections of the southernmost coast of Somalia. The Court therefore sees no reason in the present case to depart from its usual practice of using the three-stage methodology to establish the maritime boundary between Somalia and Kenya in the exclusive economic zone and on the continental shelf. The Court first identifies the relevant coasts of the parties, namely those coasts whose projections overlap. The Court, using radial projections which overlap within 200 nautical miles, has identified that the relevant coast of Somalia extends for approximately 733 kilometers and that of Kenya for approximately 511 kilometers. The Court notes that the parties disagree as to the identification of the relevant area. The Court has explained on a number of occasions that the relevant area comprises that part of the maritime space in which the potential entitlements of the parties overlap. The Court also recalls its observation that the relevant area cannot extend beyond the area in which the entitlements of both parties overlap. The Court is of the view that in the north, the relevant area extends as far as the overlap of the maritime projections of the coast of Kenya and the coast of Somalia. The Court considers it appropriate to use the overlap of the 200 nautical mile radial projections from the land boundary terminus. As far as the southern limit of the relevant area is concerned, the Court notes that the parties agree that the maritime space south of the boundary that Kenya and Tanzania, south of the boundary between Kenya and Tanzania is not part of the relevant area. The relevant area, as identified by the Court for the purpose of delimiting the exclusive economic zone and continental shelf up to 200 nautical miles from the coast, measures approximately 212,844 square kilometers. The Court next constructs the provisional equidistance line. It first identifies the base points it considers appropriate for the construction of the provisional equidistance line within 200 nautical miles of the coasts. The provisional equidistance line is constructed on the basis of these base points, and it begins from the endpoint of the maritime boundary in the territorial sea, point A, and continues until it reaches 200 nautical miles from the starting point of the maritime boundary, at a point with the coordinates indicated in the judgment. The resulting line is depicted on sketch map 9, which is now shown on the screen. The Court next considers whether there are factors requiring the adjustment or shifting of the provisional equidistance line in order to achieve an equitable solution. The Court recalls that Kenya perceives the provisional equidistance line as inequitable, while Somalia does not see any plausible reason for adjusting the line and believes that it would constitute an equitable boundary. The Court notes that Kenya, by invoking various factors which it considers as constituting relevant circumstances in the context of this case, has consistently sought a maritime boundary that would follow